Before we begin, we'd like to go over a few housekeeping notes. This session is being recorded. The slides and recording of today's webinar will be provided in the follow-up communication. Please use the Q&A button at the bottom of your screen to submit your questions at any point of today's session. We'll be addressing these at the end of the presentation, and we will do our best to get to all of them. On behalf of Baker McKenzie and IMT Group, welcome and thank you for joining today's webinar, Asia Pacific IMT Webinar Series, latest customs audit and enforcement trends in the United States. My name is Yaiko Hodaka, and I'm the co-chair of the Asia Pacific Industrial Manufacturing Transportation Industry Group of Baker McKenzie, based in Tokyo. As many of you may notice, in this series of webinars, we have learned about the customs audit regime and practice in Asian countries, including Thailand, Indonesia, Philippines, Vietnam, Malaysia, and China. And in today's session, we leave APAC and expand our scope to outside APAC. Today's session focuses on the United States. In the previous sessions, our colleagues from APAC commonly stated that after the pandemic, the governments are keen to increase their revenue by tightening the customs and audit practice. And in these jurisdictions, sometimes spotlights are on the issues, something like unclear regulations or rules, wide discretion of customs officers, and even worse case, unreasonable enforcement, which is not based on the written rules. Now, in the United States, of course, they have common issues that are typical to the customs audit, but they have a lot of different and new issues for which we need to tackle from very different angle, including, of course, forced labor. I'm sure you will learn a lot today. Now, I'm pleased to introduce our excellent speaker from the United States, Meredith Dumont, a partner from our Washington, D.C. office. And Meredith counsels U.S. and multinational companies across industry sectors on all aspects of U.S. customs law. She focuses her practice on rapidly evolving trade policy, customs compliance, and duty mitigation strategies. She was named a rising star in international trade by legal media groups' expert guides. And now I will hand over to Meredith to kick us off with today's presentation. Over to you, Meredith.
Thank you very much, Yaiko, and welcome everyone. I hope this is a helpful session as we talk about the latest developments in customs enforcement and audit trends. Next slide, please. So just to give you a view of where we're headed with our agenda, we'll start by talking about the key legal trends in this space, what we're seeing today and where we anticipate the enforcement and audit trends will go in the future. We'll then move to a high-level discussion of the audit process and the different types of audits that U.S. Customs and Border Protection performs. We'll talk about some of the best practices that companies can implement to successfully move through the audit process. And then we'll close the discussion with an overview of voluntary prior disclosures and the role that they play in the context of customs audits. Next slide, please. So we'll begin by talking about the key legal trends and what the audit and enforcement landscape looks like. Next slide, please. So right now in the United States, the audit landscape has remained fairly steady. Even in spite of the COVID pandemic, we have seen that the number of audits conducted has remained steady up until this most recent fiscal year of 2022. And although the number of audits is still substantial, it has declined somewhat. Nevertheless, during that COVID era, we have seen that the amount of revenue collected by the government as a result of the audit process did increase substantially, particularly from 2020 to 2021, with an increase in $90 million of additional revenue identified from those audits. So we are seeing that there's a fairly stable audit landscape, but there is an increase in revenue. And that may be due in part to the types of audits we're seeing. So there are essentially three types of audits in the United States. The first is the focused assessment, which is the comprehensive traditional audit where government auditors come and review the internal controls of a company and really use transaction-based testing to identify areas of noncompliance. We are seeing fewer and fewer focused assessments performed because they are very time-consuming, they are very resource-intensive, and more issues that are of noncompliance are captured by things called the Centers of Excellence and Expertise. And these are remote centers where import specialists across the country are focused and aligned on certain industry sectors, giving the agency greater insight into patterns of trade activity and noncompliance. And then the second type of audit that we're seeing more of are these single issue quick response audits, as they're referred to. These are not comprehensive audits of a company's internal controls and import activity. Rather, they look very specifically at individual areas of risk. For example, whether or not you are effectively claiming preference under a particular free trade agreement, or whether your products are subject to anti-dumping duties. So they're very narrow issue audits in terms of their scope. And then the final type of audit is the risk analysis and survey assessment, or RASAs. And these are really not formal audits. They are not performed under generally accepted government auditing standards in the United States. And they stand in contrast to focused assessments and single issue audits in that they are not focused on identifying areas of noncompliance or violations. They are instead the ability of the government to survey import activity and identify whether importers have certain areas of risk that merit further review. Now, there are a number of priority issues that U.S. Customs and Border Protection tends to focus on in audits. Those include related party valuation, that's intercompany transfer prices, anti-dumping and countervailing duties. Forced labor is something we are expecting to see in the audit context because it is right now a priority enforcement area. And then, of course, country of origin and preference claims, where companies are claiming that they are entitled to duty-free treatment on goods that would otherwise generate revenue for the government. So you might ask, how does the government decide to target my company for audit? There are any number of factors that may contribute to that. Some companies are perceived as being higher or moderate risk, and those are targeted. That's based on their patterns of trade and whether or not their trade activity implicates any of the priority issues that we've identified. There can be specific targeting into issues or patterns. That's particularly true where data analytics reveal inconsistency in trade activity. For example, unusual changes in tariff classifications being used, unusual changes in value associated with certain tariff classifications. Prior disclosures can themselves be tools that are used to target entities for noncompliance via audit. A prior disclosure, of course, is a voluntary mechanism, and it is designed to allow a company to be forthcoming in its noncompliance to gain the benefits of the protection of a disclosure, which is reduced penalties. At the same time, it can expose a company to risk because it places that company squarely within customs enforcement sites. So it has to be done carefully. And then the last thing that can really result in an audit is a referral. There are a number of other government agencies that are responsible for targeting areas of compliance related to imports, and those government agencies will often refer to customs and cooperate with customs in identifying good targets for audits where they've identified noncompliance. Similarly, that referral can come from a field officer at any one of the many ports in the United States, where those field officers identify particular trade patterns that are of concern. Next slide, please. So this next slide is really just an overview of some of those audit statistics, and it does indicate again that we're seeing a fairly stable trend in audits with a sort of increase in revenue that we think is the result of those quick response audits, which enable the government to really target and hone in on those risk areas rather than expend substantial resources on very lengthy, time-consuming focused assessments. Next slide, please. Now, this slide is important because it does highlight the current Office of Trade strategy from U.S. Customs and Border Protection. And the one thing I want to highlight in this 5-pillar strategy, which is in place through 2025, is this effective risk-based enforcement. Again, audits are very much a part of customs enforcement. Customs uses the data and analytics to monitor trade activity and evaluate that risk and noncompliance. And the audit function is an important part of that function, being able to identify importers that present risk and identify noncompliance, and of course, generate additional revenue for the agency. Next slide, please. What's interesting about the revised framework that Customs published just earlier this year is that there is now 2 new pillars to the framework for compliance. There's this new emphasis on social responsibility and supply chain traceability. Those are buzzwords that we're hearing quite a lot in the context of forced labor. So again, while we are not currently seeing a lot of auditing in the forced labor space, it is certainly an area of increased enforcement, and that enforcement is going up year after year. And so we do anticipate that in the coming year or two, we will start to see this subject to some auditing, whether that's quick response auditing or part of the broader focused assessment. Next slide, please. So again, as we mentioned, in terms of audit and enforcement, there are certain priority trade initiatives that Customs identifies as being a focus from an enforcement perspective. We've outlined those on this slide here, and I do want to highlight that currently what we are seeing the most in our practice is a review of anti-dumping and countervailing duties. Many years ago, as some of you may be aware, the GAO in the United States, the General Accountability Office, did publish a report with regard to anti-dumping and countervailing duties. And it unfortunately revealed that U.S. Customs and Border Protection had, over the course of about 10 years, failed to collect approximately $4.5 billion in anti-dumping duties. So this has, for many years since that report was published, been the focus of scrutiny for Customs. Another area that is a priority area is intellectual property rights. There is quite a lot of seized property in this area, and of course, this is an effort to protect a lot of the revenue for companies that do have those intellectual property rights. And then trade agreements. This is another area of increasing enforcement. We're seeing many more verifications of origin, and we're seeing a lot of review of companies that are self-certifying their eligibility under free trade agreements. Next slide, please. Now, notwithstanding that there are certain priority areas that the government tends to focus on, audits also include these kind of core areas. So tariff classification is always going to be something that's part of a focused assessment, certainly, and can in fact be an issue that is reviewed in a quick response audit. Tariff classification is sometimes undervalued by companies from a compliance perspective, but it is very important because so many things flow from the correct tariff classification. The rate of duty, of course, admissibility, it's a trigger for licensing requirements from other government agencies. And if the tariff classification of a product is determined incorrectly, it can result in a number of repeat errors, entry over entry, and that can accumulate substantially over time and increase penalty exposure should the government discover that noncompliance. Now, another issue that we see reviewed in audits pretty continuously is customs valuation. There are 2 sort of key factors that we see over and over in an audit and enforcement context, and that is the related party pricing, transfer pricing, and whether that arm's length price is an acceptable customs value. We also see additions to value being an area of focus for U.S. Customs and Border Protection. Things like royalties, license fees, assists, which are things that a buyer or an importer provides to a seller, free or at a reduced charge that has to be added to the price that's actually paid. Those are sort of low-hanging fruit for the agency and very easy to audit, and a very easy target for additional revenue for the government. And as we've noted, forced labor certainly is an area of increased enforcement. We are seeing a lot of focus on withhold release orders, increasing detentions under the fairly new Uyghur Forced Labor Prevention Act. And so we'd like to talk a little bit more in particular about forced labor because we are seeing such a notable increase in the enforcement in this space. Next slide, please. So again, this is a highlighted area, and we've put some statistics here to just demonstrate how pronounced and how rapid the increase in enforcement is in this area. As a backdrop, for those of you who are not familiar with this, there is a very old statute in the United States, Section 307 of the Tariff Act of 1930, and it prohibits the importation of goods that are made in whole or in part from forced labor. And now, previously, there was something that was called the consumptive demand clause, and that essentially allowed goods to be imported into the United States, even if they were produced with forced labor, if there was not sufficient supply to meet consumptive demand within the United States for a particular product. The Trade Facilitation and Trade Enforcement Act of 2015 eliminated that loophole in the forced labor law. And so with that elimination, we have started to see since 2016 this steady increase in enforcement in this space. And that's demonstrated by an increasing number of withhold release orders that have been issued. Withhold release orders are a mechanism that the government issues to identify products produced by particular companies or within certain regions, certain commodities. And when those are issued, those shipments will be detained at the border, and importers will have to demonstrate with evidence that their merchandise is not made with forced labor. We've seen this enforcement, as you can see, go in just a few years from single digits of detentions to thousands of detentions. So really an increase in enforcement. And under the Uyghur Forced Labor Protection Act and withhold release orders in August 2022, we saw 838 entries in that 1 month detained, with more than $266 million for suspected forced labor. So really a very substantial enforcement issue that we do think will eventually be an issue that is audited, and companies will be expected to have pretty well developed internal controls and social responsibility programs around forced labor. Next slide, please. Just giving a little bit more specific look at the Uyghur Forced Labor Prevention Act. It did enter into force just this past summer, June 21st, 2022. And what the law does is it creates a rebuttable presumption that goods manufactured in the Xinjiang Uyghur Autonomous Region of China are manufactured with forced labor. And so an importer that is sourcing a product that's made in whole or in part from goods of that region, inputs of that region, will need to be able to demonstrate to the agency that either their goods don't come from that region, or none of the inputs in their goods come from that region, or that those goods are not made from forced labor. And there are 3 requirements under the law to be able to rebut this presumption. Importers are going to have to comply fully with the Uyghur Forced Labor Prevention Act guidance that's been published, and in the future, any regulations that are implemented under the law. They will need to respond completely and substantively to any requests for information that the agency issues. And third, and most importantly, they will need to be able to demonstrate with clear and convincing evidence that that merchandise is not manufactured from forced labor. And that's really the critical piece, because it's a very high evidentiary burden. U.S. Customs and Border Protection has made clear that the expectation is that importers will be able to trace their entire supply chains all the way back to the raw materials to be able to demonstrate that there is no forced labor in that supply chain, which is a very high hurdle to overcome. Next slide, please. The other priority area that we do want to highlight is country of origin, and that's important in a number of different contexts. More recently, in the past 4 years or so, we have seen origin become very important in the context of Section 301 duties that have been imposed on products of Chinese origin. We've also seen it important in the context of Section 232 duties on steel and aluminum products. And of course, it's very critical for free trade agreement preference claims. And I would highlight here USMCA in particular, because it is still in the United States our relatively most recent free trade agreement. It has very robust procedures for origin verifications, and it has, in some contexts, more complicated rules of origin. So for example, the automotive rules of origin are much more complicated, and the regional value content requirements are much higher. And so we are seeing disputes about this at the treaty signatory level, where we have right now a dispute that's being settled via the dispute settlement mechanism with regard to those automotive rules of origin. So again, this is an area to pay attention to, because there is significant origin verification and auditing in this space. Next slide, please. There are a number, as we've mentioned, of triggers. I just want to highlight a few here. One in particular that's come to the fore, and we see this increasingly, are qui tam actions, those in which there are whistleblowers that report suspected or identified noncompliance to the government. That can be disgruntled employees, or just employees that for whatever reason do decide to report that noncompliance to the government. There were two very recent cases. The Department of Justice did settle under the False Claims Act, and those were both cases in which companies settled for multi-million-dollar settlements for undervaluation on their customs entries. In one case, there was a double invoicing scheme whereby the government was presented with a false invoice with lower values. The other company had a False Claims Act settlement for undervaluing due to unreported assists, things that were additions to the value that were not captured in the import entries. Another thing I would like to point out here is intragovernment coordination. Very often, companies don't appreciate that customs is not the only agency that provides a source of information for auditing enforcement. A number of other government agencies are involved, because U.S. Customs and Border Protection in the United States does enforce the laws of many other government agencies: the Environmental Protection Agency, the Food and Drug Administration, the Consumer Product and Safety Commission, many others. So to the extent that those other agencies have their own field officers collecting data, there is coordination between those government agencies, and that can be a trigger for an audit. Next slide, please. So now that we've kind of identified what some of those enforcement priorities are, what the trends are, and where we see audits going, let's talk about what the audit process looks like in the United States. Next slide, please. So at a high level, of course, U.S. Customs and Border Protection is the auditing agency in the United States. It sits within the U.S. Department of Homeland Security, and it is one of the largest law enforcement agencies, not only in the United States, but in the world. The department within CBP that is responsible for audits is Regulatory Audit and Agency Advisory Services. That organization uses a risk-based approach in their audits, and it does have field offices throughout the United States. Next slide, please. This is an overview of the field offices. If you study this slide, you will see that there are field offices again throughout the country. What's interesting is that not only do they have a regional presence to be able to conduct audits at all of the major ports and all the major regions in the United States, but they are also aligned with very specific issues. So that allows people and offices within regulatory audit to have specialization and really deep expertise into a number of compliance areas, so that they can have that cross-regional support. Next slide, please. Now, as we mentioned, there are three types of customs audits. The first, of course, is a focused assessment. So the procedure for a focused assessment is very formal. There are procedural obligations that must be met, and although this is still the only type of comprehensive broad-based audit, as we noted, we are seeing a declining number of these just because they are so resource intensive and time intensive. And so increasingly, we think the government is finding that the quick response audits are a better way to target noncompliance and also achieve more increase of revenue by doing more and more quick response audits. Nevertheless, the focused assessments are still very much present, and they are being performed. They were introduced in 2001, and the method for doing the audits was refreshed in 2014. And that refresh basically has three phases. The first is the pre-assessment survey process. An importer will receive a letter notifying it that it will be subject to a focused assessment, that it has been selected. There will be an opening conference, and the importer will be sent this pre-assessment survey. That survey seeks to identify management support of the compliance program, the types of internal controls that the company has in place to manage its risk and ensure that it's complying with the customs laws of the United States. And it will also seek to identify the areas of responsibility. Who's responsible? What is the communication like interdepartmentally? What type of testing has the company done? And then the next phase, once that survey is received, is the assessment compliance testing. And that is transactional testing, whereby the auditors use targeting methods and data analytics to identify specific import transactions that they will review and for which they will request supporting documentation. And that will be a time in which there is a bit of back and forth between the auditors and the company being audited. And they're going to be looking very carefully at very targeted entries to see if they can identify a number of areas of non-compliance. So CBP auditors are very good typically at selecting those entries and those import transactions where there tend to be inconsistencies. And so we have seen that in those focused assessments, we have to create a story and understand what happened in those transactions to be able to explain that to customs. Following the transactional testing, there is a follow-up audit. And that is, there's a meeting with the auditors to have those follow-up questions and have those discussions to ensure that there's clarification over processes and procedures and controls. Once the audit is complete, and those audits may take months, there will be an audit report that is prepared by the auditors. They will either determine that the company is an acceptable risk or an unacceptable risk to the government. And if the company is an unacceptable risk, they will issue what is called a compliance improvement plan, or a SIP. And that will mean that the company has to achieve certain markers in that compliance improvement plan. And customs will come back and sometimes even do additional transaction testing to make sure that the company has fulfilled the obligations set forth in the compliance improvement plan post-audit. With the audit report, the government may also issue a demand for payment of any additional duties that are owed as a result of any non-compliance that was identified as a result of the audit. Now, what we have seen with the refresh of the audit process for focused assessments in 2014 is that auditors do now have greater discretion on what to test. So they may decide that they would like to focus the focused assessment on valuation, tariff preference claims, and do less focus on things like tariff classification or country of origin issues. They also have more flexibility in deciding how much they want to test. So there isn't a set number of transactions that auditors will choose. It will depend on the volume of the importer's trade activity, and it will also depend on the number of different priority issues that the importer is engaged in. And then finally, they will have some discretion as to how far back in time they want to look. The statute of limitations in the United States is 5 years. So the government can, in theory, go back 5 years to look at your import transactions and collect any additional revenue that is the result of any violations of the customs laws. Now, it's not uncommon in the context of focused assessments for auditors to seek what are called statute of limitations waivers. Those effectively toll that statute of limitations and preserve the government's ability to issue that demand for payment following the audit. Some auditors will, in fact, give companies the opportunity to make disclosures to protect against penalties where noncompliance is identified. That's at the discretion of the auditor. And at the conclusion of the focused assessment process, if the company is an acceptable risk, they may also be invited to join what was formerly the Importer Self-Assessment Program, is now the CT-PAT Trade Compliance Program. And this is a program in which, by virtue of being a member, you are removed as a company from the audit pool for focused assessments. And you do have certain eligibility requirements. So you are required to sign a memorandum of understanding. You are required to disclose non-compliance as it's discovered. You're expected to file disclosures where you identify non-compliance. But there are certain benefits, and one of the primary benefits is that you are removed from that audit pool going forward. Next slide, please. So in addition to the focused assessment, there is, of course, the quick response audit. Now, typically we see that quick response audits are the result of a referral, as we mentioned, for some type of identified non-compliance. And they are usually focused on revenue-related issues and priority issues, such that, if you have non-compliance that doesn't result in a loss of revenue, you're not likely to get a quick response audit covering that issue. What we see most often is customs valuation issues. We see preference programs, again, those free trade agreement claims, and anti-dumping countervailing duty issues covered by quick response audits. We have in particular seen a lot of anti-dumping countervailing duty investigations and audits that are started based on requests for information. The Customs Form 28, that's a request for information from a field officer. A Customs Form 29, which is a notice of action, which typically follows that CF 28 request for information. Those can lead to some of these more targeted single issue audits where the field officer has identified non-compliance or potential non-compliance. And these are also the types of audits that we mentioned before that are driven by the Cs, the Centers of Excellence and Expertise. They have those targeting procedures, and they have that data analytics, and they're much better able to see the trends and the patterns of any one importer within an industry group. And that can lead to the identification of non-compliance and referral for these types of audits. Next slide, please. So the final type of audit, which is not technically an audit, is again that risk analysis and survey assessment. It's not a formal audit, and it's not controls-based. The government is not seeking to understand whether the company has appropriate controls on all of the substantive compliance areas to understand whether they've mitigated their risk appropriately. They don't utilize the generally accepted government auditing standards, but there are some similarities in the process. So while it's not as formal and it's not as time intensive, there may be interviews between CBP and members of the compliance team at a company. There may be some transactional testing. And instead of a very formal closing audit report, there may be a closure letter. Again, what CBP is seeking to do with these types of surveys is to simply identify areas that may merit further review by the agency. So sometimes you will see that the risk analysis and survey assessment leads to a referral for a more formal audit. But it is really just trying to understand the risk that that particular importer presents and whether it merits further review. Next slide, please. So now that we've kind of gone over the different types of audit processes, let's talk a little bit about best practices in the audit sphere. Next slide, please. One thing we tell companies is if you import meaningful volumes or your import activity is in one of those trigger priority areas, you should expect that you will be audited, and you should be planning for it, right? You need to be prepared the day you get that letter saying you're under audit. So you want to make sure that you understand the audit methodology that will be used, and we've given you that overview here. But you also want to understand what are the areas of concern for the auditors. Are they going to be looking at your tariff classifications? Do you use a lot of related party transfer pricing, and is that likely something that's going to be examined? Have you in the past claimed that your goods are subject to anti-dumping duties, and is it possible that they're going to be reviewing that? You want to understand your import activity, and you want to make sure that your internal controls are tailored to that activity, because that is what the government's going to be seeking to understand, whether you're tailoring those controls to your activity. And one way to do that is to pull your data out of the automated commercial environment. In the United States, that is the single window electronic system in which entry documentation is submitted. And once you get that data, you want to be able to study it and do some data analytics and see what your risk areas are. Next step. Next slide, please. Thank you. So the next step is to really focus on those internal controls. You want to understand what your import activity is, and based on that, you'll identify your risk areas. Do you have a lot of tariff preference claims? Are you claiming duty-free treatment under free trade agreements? Are you sourcing a lot of merchandise from vendors that are located in regions that are known to be higher risk for forced labor? Those are all the types of questions you should be asking as you study your import activity. Then you want to tailor your controls to mitigate those areas of risk. And then, of course, in any good compliance program, you will want to test your controls. Do some post-entry auditing. Do it on a risk basis to see that your controls are effectively preventing non-compliance. And if you do identify non-compliance, you need to really understand what the source of that non-compliance is so that you can revise your controls to address the non-compliance. You also may want to consider the voluntary prior disclosure before the audit begins, to the extent that you have identified non-compliance or violations. Note that there is a cost-benefit analysis that needs to be done. It does not always make sense to file a prior disclosure. There are some violations for which prior disclosure will not offer any protection. There are some violations that are subject to things like liquidated damages rather than penalties under the primary penalty statute. So you just need to understand what the protection is and whether it makes sense to just correct in the future the violation, or whether you should file that disclosure. The other thing we recommend is that from a customs perspective, it's very important for individuals in a customs compliance department to really speak to colleagues in other functional areas of the company. For example, tax, research and development, accounts payable, because there is so much overlap between the customs compliance function and the roles that those colleagues play. You need to understand what the internal business processes are at your company to be able to effectively create internal controls that gather the information that's required to ensure compliance. Next slide, please. Now, once the audit is underway and you've been notified that you're under audit, it's very important to kind of control the audit narrative. You don't want to sit back and take a back seat and let the audit unfold. You want to be very proactive and have a plan. And you want to, at that opening conference, if it's a focused assessment, you want to tell a story. You want to project that your management is very supportive of the compliance program. We often recommend that in that opening conference, a member of executive management attend the meeting and reinforce that message to U.S. Customs and Border Protection. We also think that it's important that you understand what the auditors expect to see for that company to pass the audit as an acceptable risk. And so part of that is really telling the story of how your company manages customs compliance, understands its obligations, and does actually put into place checks to ensure that the company's complying with all applicable laws. Now, it's also important to recognize that in most audit contexts, there will be some non-compliance discovered, and that's to be expected. So it's not a reason to panic. What matters is how the company chooses to deal with the errors that are discovered. And you can use that as an opportunity for improvement. So many companies and individuals within companies will be quite upset when they receive a notice of audit, and it will cause quite a lot of angst. But really, the audit is an opportunity to examine more closely your internal controls and identify areas for improvement. So viewing it through the lens of opportunity is often a way to ensure that not only are you successfully managing the audit, but you're also learning from it and you're making improvements that will reduce your risk going forward. Next slide, please. So the last component here that we want to talk about in the context of audit is the voluntary prior disclosure and the role that it plays. Next slide, please. Now, voluntary prior disclosures protect companies from penalties, but only under the primary civil penalty statute from customs, which is 19 U.S.C. section 1592. And this is a culpability-based statute in which you are assessed penalties depending on the degree of culpability involved in the violation. And it ranges from negligence to gross negligence to fraud. And on the lower end, we have the penalties for negligence, which range from 2 times any duties, taxes, or fees that are owed as a result of the violation, where there's a loss of revenue, or if the violation does not result in a loss of revenue, 20% of the dutiable value. So an example in a very modern context of a negligence violation could be a forced labor violation, where the merchandise is prohibited and you're attempting to import it. And it doesn't necessarily result in an underpayment of duties and fees. Nevertheless, it is a violation of law. So customs could assess a penalty of up to 20% of the dutiable value of the merchandise. Gross negligence, of course, increases the amount of that penalty to 4 times the loss of revenue, or where there's no loss of revenue, 40% of the dutiable value. And then in cases of fraud, which is knowing an intentional violation of the law, the penalty can be up to the domestic value of the merchandise. Next slide, please. Now, the prior disclosure mechanism is a voluntary mechanism. You can disclose errors in your entries and your entry documentation to customs. And if that violation, like we said, was subject to negligence or gross negligence, if you file a prior disclosure that is accepted, then that will wipe out the penalties. So you will not be subject to that 20% or 2 times the duties or fees, or the 40%, 4 times the loss of revenue. Instead, you will only owe any interest on unpaid duties, if to the extent that that exists. In fraud, there is a mitigation in the penalties to 10% of the value of the merchandise. Now, if the importer in order to receive the benefits of the disclosure, the importer has to be able to file the disclosure before the government has initiated a formal investigation of the violations. And there, typically when there is a formal investigation, U.S. Customs and Border Protection will send to the importer a formal letter indicating that the company is specifically under investigation for certain issues. Many times companies will think that because they've received a request for information or a notice that they're going to be under audit, that is the equivalent to a formal investigation. And it is not always evidence that the company is actually under a formal investigation. So even in the context of an audit where you receive an audit letter, it still makes sense to go back and review your import activity and see if you can identify violations and errors before the audit is in full swing, because you may still be able to meaningfully mitigate potential penalties by identifying those violations and filing a prior disclosure before the conclusion of the audit. Next slide, please. Now, in terms of best practices in filing a disclosure, there are certain things to bear in mind. If the company chooses to file a disclosure, the first thing to do is to not simply address the violation or what went wrong. You want to make sure that not only are you identifying the violation, but you're also demonstrating that your internal controls were what allowed you to identify that. So if that's part of the story, then that's what you should say. Customs likes to see that even though you may have had non-compliance, you have internal controls in place that caught the non-compliance. That means your internal controls are working. And that is a good narrative to be able to incorporate into an audit process. And very often we do, in representing companies in audits, recommend that disclosures be filed early on in that audit process, and that becomes part of the narrative. You also want to be sure that you have taken steps to revise controls to correct whatever those facts were that led to the violation. Customs likes to see that you have a full appreciation for why things happened, not simply that they did happen. That gives the agency reassurance that you understand why the noncompliance happened and therefore are able to remedy it and ensure that it does not recur in the future. And that's part of anticipating and addressing questions that the government might have in the audit in the context of the disclosure. If they can be reassured that you know why the noncompliance happened, whether it was because of a failure of communication or because your control simply didn't address certain facts, then that's not something they need to necessarily follow up on. You've addressed it in the context of the disclosure, and they can move on from that issue. So again, prior disclosures can be very valuable, and they can mitigate risk and penalties if they're done correctly and in a way that assures the government that the noncompliance has been corrected on a going forward basis. Next slide, please. That brings us to the end of the program. We're now open for a Q&A session. So if you do have any questions, please go ahead and provide those to us. We will be able to address those. I do have one question here, and that is, in the context of forced labor, are you starting to see any audits, whether quick response or otherwise? And again, in that context, we are not yet seeing U.S. Customs and Border Protection actually engaged in audits to date. So what we are seeing is increased enforcement. There are a number of detentions of merchandise for suspected forced labor, and we're seeing that both under withhold release orders as well as the Uyghur Forced Labor Prevention Act. We are not yet seeing quick response audits, and that's sort of an evolution. So typically when you have something that is new laws, enforcement happens first. And once companies become mature and are really able to respond and have instituted procedures, the expectation is after that law has been in place, then you start to audit companies to see if they have put into place those controls and those compliance programs. So that's where we are with forced labor. We do expect that will be happening in the near future. And I don't see any other questions at the moment. So again, if you do have questions, please feel free to submit those to us. We will respond to you. But thank you again for your attention, and I will turn it over to Yeko to wrap up.
Okay, thank you very much, Meredith. Please join me in thanking our speaker, Meredith, for an excellent presentation on the latest customs audit trends in the US. For more information, or if you'd like to discuss further, please do reach out to us. And on behalf of Baker McKenzie and the IMT group, thank you for joining today's webinar again. We hope that you found this session informative and relevant for your organization's operations. We would appreciate your feedback through a short survey, the link for which will appear on your screen after the session has ended. The next session in this series will focus on EU and the UK and will take place in November. Details to be available in due course. We look forward to having you there. Goodbye for now and have a great rest of the day ahead. Thank you very much and bye-bye.